You're watching the Front Row. Thank you for staying with us. We asked you whether Chief Justice Marth Koome should go ahead and swear in the 6 judges that President Uhuru Kenyatta rejected. Let's take a look at some of your views before we get back to the conversation. Kipleting Manuela says, should President Kenyatta fail to obey High Court order, then CJ Marth Koome will have no choice but to swear in the 6 judges. And he goes ahead to say that the swearing in is long overdue. President Kenyatta has no option but to obey the High Court order. The judiciary is the last line of defending our constitution. Let's take a look at something else. Pius Kiprono says, Chief Justice Marth Koome should proceed and appoint the 6 judges as per the court order. It seems the president has abdicated his role and has no regard for the rule of law. We also have... When President Japheth says, when President Kibaki and Raila closed themselves to negotiate after the 2007-2008 PV, the Grand Coalition was born. When President Uhuru and Raila did the same, the handshake was born. The CJ and the president need to close the door and end this stalemate. Perhaps another handshake between the president and the CJ. We'll talk about that shortly. Someone else says, why don't we respect the presidency? Don't hate the president, but disagree with the presidency. Let's take 2 final ones. Evans Rotich saying, the law is very clear. When judges are vetted and approved by JSC, the president has no choice but to appoint them. CJ must unconditionally swear them in. And the last thought before we get back to this, Martin Kigodho says, what does the law say? Let her do what the Constitution requires her to do with regards to swearing in the judges. Almost everyone seems to think that the judiciary is really under siege on this one, and the CJ should really bite the bullet and do the hard thing that we all think would be to swear in the judges. But Alutalala, let me come back to you on some of the options that CJ Koome says. We say she should go ahead and appoint these judges. The Attorney General raises another question that's saying that the 6 judges, once they have been appointed to the respective courts, they cannot be removed from office. What do you think?
I don't follow that.
Yes, in this particular. So he says, once they have been appointed by the Chief Justice, without following the law, then what would be the process of removing them from office?
Okay.
That's a question.
I gather that the context in which the AG is raising that is that he is trying to persuade the Court of Appeal to grant the temporary stay, because if you don't, then the horse will have bolted already by the time the decision is made. Yes, because the removal of the judge takes a constitutional process, and that isn't easy. I think, as we have said here, and we seem to agree, the correct thing to do for the Chief Justice is to obey the law. The best that she can do for this country is to obey the law. And the law and the orders as have been rendered by the High Court, barring any other orders from that particular appeal that has been lodged, is that she must appoint these judges. The
other argument, and I'm sorry to cut you short, I'll let you finish that point, and we've just talked about it right now. Some legal minds are making the argument that the rain started beating CJ Koome on this particular issue when she agreed to swear in the other 34 judges, that Chief Justice Emeritus David Maraga had done a good job to say all the 41 or none. So then she comes in and she agrees, okay, we can swear in this, then maybe we can have a conversation around the 6. This makes her work even harder.
It's an interesting way to look at it. What that seems to be saying is that when Justice Koome came in, she caved in to the pressure by the executive, yet her predecessor had dug in, stood on his hind feet and said, is a package or none. Look, in life, people do things differently. Justice Maraga was a neat guy, and he was a firm guy. That is not to impute the converse on the Chief Justice presently. However, in the eyes and in the view of Justice Maraga, since the entire package had been appointed, so to speak, loosely, then they ought to have come as a package. In the eyes and the view of Justice Koome, really, what is before her is what she'll deal with. In any case, as my younger brother here has alluded, it can happen that it is not the president who has refused to appoint them, but somebody is unwell, somebody is indisposed. That doesn't stop the rest from being sworn in.
Appointed.
So I do not think there's a hard and fast one there. The thing that I think would seem to go that direction, Kisa, is the fact that the Chief Justice appointment came amidst of murmurs and complaints that the process had not been done neatly. Right from the chair of the Judicial Service Commission that was vetting, all the way to when the results were supposed to be made public, there were murmurs and rumors. Thereafter, after she was appointed, the president rolled the carpet for her, if you like, by saying, now, we appoint these guys. Those are perceptual issues. They are perceptual issues that could tend to paint a picture that Justice Koome is willing to play ball with the executive. But it's neither here nor there, really. It's no hard and fast rule. What I think is that we must give Justice Koome her chance and let her do her thing.
Steve, what do you think? That perhaps she should have followed through what the predecessor did, 41 or none? And does it put her in a very precarious situation that, on the other hand, the president has said he has issues with these appointments? She talked about changing tack, being more consultative, negotiating. But do you see negotiations work on this particular issue?
I think there's a moral argument on this statement that appoint all or none, but it's not a constitutional argument. So let's clarify that. The constitutional argument is for an applicant to the position of judge, having been vetted, having been interviewed, and having been recommended for appointment, could as well be sworn in as an individual, one by one. The reason why we do swearing in en masse is for administrative and logistical purposes. Consulting the president's diary, making sure that it's there, is available, so that we clear all this at once. But it is not unconstitutional to swear each judge one by one. But there is a moral argument, as I've said. Why leave out others? Why swear them in part when you can swear them together? I think what is unconstitutional and illegal is the decision to leave out others for reason that you feel they're not qualified or should not have been nominated for judges, as to be appointed as judges. In any case, Akisa, Justice Weldon Korir and the other judges have been serving judicial officers that even if there were integrity questions around their suitability, nothing stops anyone from raising a petition with the JSC and they shall be removed in the same manner. So I don't think the Constitution permits, the Constitution does not permit the president to express an opinion once he's been supplied with a list. So whether you choose to press...
And I imagine that's what Maraga was trying to...
Yes, so what Maraga said, but then in terms of swearing in, it would not be unconstitutional to have made part swearing in. So Maraga's style has a lot of political value because it comes with pressure. CJ Marth Koome relieved some of that political pressure from the president, but not where we are now. Again, we cannot make this matter any simpler than it already is. It's as simple as the fact that the CJ Marth Koome, in the absence of a stay order and following the failure by the president within the 14 days to appoint the judges, she must comply with the court order. The court order binds her and she must comply. And she will do no more than just complying. So when she swears in the remaining judges, pursuant to the court order, she'll be advancing constitutionalism and respect for the rule of law, rather than being seen as undermining or disrespecting the president. The political backlash may or may not be there, but I think we must understand her role.
As a Chief Justice.
When she swears these judges to be acting in compliance with the court order, we cannot approbate and reprobate compliance with court orders. On the one hand, we're decrying the failure by the president and the state officers for non-compliance with court orders, and then on the other hand, you're saying it may raise political tension if the CJ swears in. I think it's a matter of course that she must comply in the absence of appointment by the president. So the president himself has the first opportunity to diffuse this tension by just appointing.
He's already made it very clear.
If he's not going to do that, the Court of Appeal has the second opportunity. Now that they have been moved, the Court of Appeal has the second opportunity to stay the order of the High Court. If the Court of Appeal does not stay this order in 14 days and the president has not appointed, the Chief Justice will do what she ought to do, which is to swear them in.
Dr. Lutalala, what then will this mean in the event she picks the option of swearing in these judges as obliged by the courts? What does this mean for the already bad situation or relationship between the executive and the judiciary? And what position does it put her, given that she only just came to the helm a few months ago?
Sorry, excuse me.
And as you answer that, does she need to deal with this politically or legally?
Well, it's both ways. At the high level, you need political goodwill from the big boys and big girls. At the same time, you need the sound backing of your professional colleagues, because when your day comes, you'll need their support when your day in the guillotine comes. And believe you me, at that level, it does come. So I'm not sure whether by her going ahead and complying with the court orders, her antagonism of the president will be perceived as severe as it has been with the Honorable Maraga. You know, Honorable Maraga had a history. First of all, he asked the president and the deputy and Jubilee government when he pronounced him, when the court pronounced itself against their declared win. That is where the rain started beating Honorable Maraga. So it is not possible to predict with certainty whether the same passion of disagreement that manifested between the head of state and Justice Maraga will be the same with Justice Koome. Because Justice Koome has come in at a time when it was perceived that now the problem is over, now we are on the right track. And you could see the president's demeanor when the swearing-in was going on. It's like, it's a new chapter. So whether or not the president will feel sufficiently antagonized by Justice Koome's move to swear them in, if it leads to that, it cannot be predicted with certainty. However, what is clear is that the president has been handed a lesson in respect for the rule of law, to the extent that despite numerous disobedience of court orders, the court has made this decision, in my view, based on the realization that we are setting into a helpless situation in terms of constitutionalism, and this has been made. So, in my view, the president has something to learn from this decision. But whether the swearing-in will have an impact of huge magnitude, like it would have been with Honorable Maraga, is a matter of wait and see.
Yes. All right, we have 2 minutes. I'll give you a minute each as we wrap up. Now that this is at the Court of Appeal, what do we expect to see in the coming days, Steve?
I think we expect to see a fierce legal battle at the Court of Appeal. This is a matter that will be fiercely canvassed, because we want to see if the Court of Appeal will grant that stay or not. I'd like to think that there's a justification for granting the stay to allow parties to canvass this appeal on the merit. However, there's another important constitutional conversation that needs to happen, even as we follow the conversation on appointment of the judges after the president has become functus officio. The other parallel conversation that is now been left unattended or neglected is that I mentioned Article 145 of the Constitution. Where is the National Assembly to commence the process of recall of the president? Where are constitutional commissions?
You know where they are, Steve.
No, I mean in terms of animating their independence, because one of the
you know why they're unable to do that.
Whether the president is functus officio or not is a legal question that will be determined all the way to the Supreme Court. But the incontestable fact is this: the president has deliberately failed to appoint some judges, which is a function that has been allocated by the Constitution. When the president fails to perform a constitutional function and he explains it away, and the Constitution does not permit him to explain it away, and the courts that have said that in our reading of the law, and I've said in terms of the hierarchical order, when it comes to interpretation of the Constitution, no one has a superior voice than the High Court, the Court of Appeal, and the Supreme Court. Where is Parliament to commence impeachment proceedings? Where are constitutional commissions? Because these are institutions created under the Constitution to support the judiciary. We are burdening the judiciary.
Not much time. I need to give Dr. Lutalala time to give us his closing remarks. What do we expect to see at the Court of Appeal?
First, it is expected that a stay will be granted. Because when you are launching an appeal, you raise what you call arguable points of law. From what I have perused very quickly, there are. So we expect that a stay will be granted. Thereafter, and it's the reasonable thing to do in the circumstances, because when you refuse to grant a stay, you are actually allowing the orders to run to the full course, because by the time you hear the appeal, then it is water beneath the bridge. So the stay ought to be granted, in my honest view, and the parties ought to be allowed a platform to argue substantively.
All right.
However, Kisa Wandera, usimlaumu mwewe kwa kula vifaranga. Uliza kuku, mbona kapeleka vifaranga kwenye nchi tambarare.
We need another show for you too.
I mean, I'm blue. I don't understand.
I'm sure Steve has not gotten anything. We'll explain that to him when we get out.
As we get out of here.
Steve Ogola is an advocate of the High Court, as well as Dr. Lutalala Mkhwana. Asanteni sana for coming in, giving us a legal perspective and also political undertones with this. And whether the Chief Justice will be dealing with this legally or politically is a matter of wait and see, even as we take a look at how the Court of Appeal will canvass this particular case that the Attorney General Kihara Kariuki has appealed there. Thank you very much for joining us here on the Front Row. I am Akisa Wandera. I'll see you next week, same time, same place, with a different topic. Have a good one.